Gotta use the mic.
All right. Good afternoon, everybody, and welcome. We really appreciate Holland Home for bringing us in for this event today, and it's delightful to see all these human beings that we can actually see your faces, and it's wonderful. So it's a blessing for us to be here. We really appreciate the opportunity. I'm Laurie Murphy. I'm an attorney at Miller Johnson, and what you see in front of you is Miller Johnson's estate planning and elder law group. We have two lawyers, myself, Laurie Murphy, and Bobbi Hines. And we have our two amazing paralegals, Susan Meier and Korolewicz. They weren't going to let us do our own introductions, but then they tried to pronounce Lauren's last name, and they said we should probably do our own introductions. You have in front of you a very thick outline. There are 98 slides for you. We are not going to cover 98 slides. It will be past my bedtime by the time we did that. We're going to hit some high points. We're going to leave some time for questions, but we've packed a lot of information into this outline so that you can use it not just for today's presentation, but as a resource as we go forward. So I'm going to kick things off just by talking about just some basic important estate planning information. All of you probably already have an estate plan, which is good. So that for most people, an estate plan would include a will, a trust, powers of attorney, patient advocate designations or medical powers of attorney, and then coordinating all those things with beneficiary designations, do not resuscitate orders, and those sorts of things. So when we think about estate planning, the first thing we think about is who's going to take care of everything in the event of my death, and that is who will tie up the loose ends of my life, who will file my final tax return, make my funeral arrangements, pay my final bills, and then distribute everything out to whoever is supposed to receive it. Do I have to worry about probate? Again, a lot of us will have a revocable living trust because generally if assets are in your revocable living trust, they don't have to go through probate. Probate is just a court-supervised process of transferring things from the name of the person who's deceased to the name of who's ever supposed to get those things when you die. I think one of us has the microphone on maybe? Or maybe it's me. It's me. All right. So if you have beneficiary designations pass without probate. Joint ownership passes without probate. Assets in your trust pass without probate. If you have a will, but you don't have beneficiary designations or joint ownership or a trust, a will does go through probate. So if all you have is a will, you will have to go through the probate court to enact that will to take care of how your property is distributed after your death. Sometimes people prefer to avoid probate by some of those other things because they don't like the fact that probate is a public proceeding. So family, friends, neighbors, others can see what's in your will. It's more expensive because instead of you, your family, and your lawyers taking care of things after your death, you have additional court fees and court supervision, and that's an additional cost for you. As we have watched the news, you'll see that there are a lot of proposals about changes in the transfer tax. So people worry about, am I going to lose all of my money to taxes in the event of my death? Well, right now, there is an $11.7 million per person exemption against federal estate and gift taxes per person. That is slated to drop to $5 million per person in 2026. That could happen sooner depending on legislation. There's proposed legislation to drop that exemption to $3.5 million per person at the end of this year. Most people don't think that's going to pass. So unless your estate is larger than those very high numbers, you're not going to have to worry about federal estate tax. In addition to that $11.7 million, you can also, without even telling the IRS, give up to $15,000 per person per year without any Internal Revenue Service tax consequences. We're going to come back to the fact that Medicaid and governmental benefit programs do not give you that same $15,000 per person per year exemption. That's purely a tax number, not a Medicaid number. So just because the IRS says you can do it, doesn't mean that Medicaid says you can do it. So if you have a trust, you should think about whether you've transferred assets into your trust, whether you've retitled things so that they are controlled by your trust at your death. Things like your vehicles, cars, boats do not need to go into a trust because those can typically be transferred through the Secretary of State's office. If you have beneficiary designation assets, things like annuities, IRAs, life insurance, all of those things typically should name your spouse as primary beneficiary and individual family members, not a trust, as the beneficiary, because there are tax consequences, particularly involving IRAs. So the other part that we think about when we think about just your regular plain old estate planning that you should periodically take a look at is who handles things for you if you are incapacitated, if you're unable to manage things for yourself. And that's that durable power of attorney. And again, most of you already have a durable power of attorney, but what you should probably check is, are the people that you've named in that document still the right people? Are they still alive? Are they still competent? Are they still able to take care of things for you? Sometimes people think they don't need to worry about a power of attorney because they've got things owned jointly with their children. Joint ownership can be good because every joint owner is considered an owner. So the good thing about joint ownership is if my son's on my bank account, he can pay my bills because that joint account is considered his money as much as it is my money. The bad thing about that joint bank account is if he wants to pay his bills, that money is his money as much as it is my money. My son got divorced. Thankfully he's not married yet, but if he got married and got divorced, his ex-spouse could get all the money in that account because it's his money as much as it is my money. So there's good and bad about joint ownership. It does not take the place of a durable power of attorney. Sometimes people think they don't need a durable power of attorney because they have a will that appoints their child or family member as an executor or a personal representative. Your will is only relevant after you die. It doesn't help you take care of things if you're alive but incapacitated. Your spouse does not automatically have the right to take care of things for you, so most of the time, people will name their spouse as their primary durable power of attorney, and then they'll name a successor if their spouse cannot act on their own behalf. We're looking through this stuff. So your durable power of attorney expires when you do. So when you die, the person you've named as power of attorney no longer has the authority to act. At that point, your trustee, or if you don't have a trust, or if you have assets not in your trust, the executor or the personal representative of your estate takes over to manage things for you. So just remember, your power of attorney goes away as soon as you're deceased. If you don't have some of these documents, you may end up in court with a court-ordered guardianship or conservatorship. The last thing I'm going to talk about is your medical decision maker. Who makes your medical decisions if you can't do it for yourself? So under Michigan law, you make your own medical decisions until your doctor or your doctor and a psychologist determine that you are no longer able to make your own medical decisions. Michigan law says that you are in charge of your own care until such time as you cannot be in charge of your own care. Michigan calls that a patient advocate designation. You will see it called all kinds of things. A healthcare power of attorney, an advance directive, a living will. Those are really all the same thing. Who do I want to make my medical decisions in case I can't do it for myself? What I encourage you to do is make sure that you have talked to the person who would make your decisions so that they have an idea of what your wishes are with regard to your medical care. So a lot of people say the same thing. If there's no chance of quality of life, I don't want extraordinary treatment. Most of us feel that way. Well, what do you mean by no chance? Are you a 1 in a million person? Or are you a 1 in 2 person? What do you mean by quality of life? If I can't run a 7-minute mile, never could, but if I can't run a 7-minute mile, is that quality of life? Quality of life for me if I can sit on the couch and binge watch Netflix, but that's just me. What do you mean by extraordinary treatment? So as we've seen some of our loved ones go through COVID, Maybe you would have thought that being on a ventilator, even on a temporary basis, was extraordinary. Maybe you think, well, gosh, if I can get that and then get better, maybe that's not extraordinary. Have those conversations with your loved ones, because their best peace of mind comes with knowing that they are following your wishes. So that's really my quick introduction. We've got a pretty limited period of time. So again, there's a lot of information in here, and I'm going to now switch over and let Bobbi start talking about long-term care issues.
Hello everyone, Bobbi Hines. Very nice to be here today. If you thought that everything Laurie just went through was a lot of information, brace yourself. Because the next is where we're talking about long-term care. And long-term care involves a number of different steps or phases that we may end up finding ourselves in, or our family finds ourselves in. And this is a lot of information. And I often refer to it as drinking through a water hose, a fire hose. It is a lot, and I certainly don't expect you to absorb all of this information today. And I'm hoping that, as Laurie said, we're touching the highlights to give you ideas of what to look for, what are red flags, but at the very least, when to call an attorney. All right, so that's what we would like to get out of it today. So moving forward, the next phase is we will talk about that long-term care. Long-term care involves that process where we begin to age and begin to need more assistance with our care, whether it is independent living, assisted living, or full-skilled nursing. And that tends to be the transition that we may find ourselves in. And independent living is where you're at home most of the time. There's independent living facilities as well, where you're able to still continue to manage all your daily affairs, but there is someone there in case something happens, in case you need assistance with something. Independent living is much like you do today. The next step tends to be assisted living, and this really begin to progress down this area as we begin to need more services. Just different things to help us. We might start off with some medicine management. We may start off with just needing some assistance from wheelchair to bed, or bed to wheelchair, or showering. All of these different things are considered activities of daily living. All right, and when we have activities of daily living, the more needs that we have. Sorry, was that me? No. Oh. I think she couldn't find her phone. In any event, so those services, as we need more services, that's when our care continues to progress, and whether or not we need more assistance, whether it's from family, whether it's from in-home care providers at home, or in an assisted living center. As we're at home, our options tend to be where we're allowed to bring in in-home care, and then we're looking at those costs as something very different from what we're used to. We're starting to look at hourly fees that are higher, longer periods of need that we have from our caretakers. And so inevitably the question that comes up is, who pays for this? How does this get paid? And my guess is that's a big part of why a lot of you are here today, is how do we get this paid? Right, and so with each phase that we transition through, from independent living to assisted living to full-skilled nursing home, there's different payment sources that are available. And they're not always available in each area. And so as we talk through these are things that, by all means, in the future, reach out and ask us questions if it's not clear, because I know we're going through it pretty fast. Independent living, one of the best sources of being able to pay for that in-home care is your, if we can apply for VA benefits. That's one of the things that I like to look at first to see if VA benefits are available. And even yet before that, we look to see if the client happens to have any long-term care policies. Long-term care policies are those policies that we pay for someone to come into our home, but then they can also help if we're at assisted living level. And you see me talking with my hands a lot because when I typically do this, I have a whiteboard and I'm drawing all over the place. So please forgive my hands. I will try to keep those in check. Nevertheless, moving forward, independent living, if we can get long-term care that is able to cover it, wonderful. But if we can't, then we like to look at VA aid and attendance. But in order to qualify for VA aid and attendance, there are certain requirements. We have to have a qualified veteran first. And what that means is you have to have been in the service for at least 90 days, one of those days during a wartime period. Now, 90% of the time when I meet with clients, they can almost always fit within that rubric. But there was a time in our history that we actually weren't at war. And that is between 56 to 64 is really the main area that I see people fall into if they don't qualify. Other than that, There's a number of different series, and we show it on one of the slides here because I'm talking ahead of myself. It does show the different wartime periods that we've had in the United States. So in case you're curious as to the specific dates for each wartime and whether or not you'll fit into that, that is listed in our slides. Oh, I really skipped it then. When you have VA aid in attendance, what that benefit is when we're able to get you qualified. There's the qualifications of being a qualified veteran, but then you also have your income and your asset qualifications. And that's really formula. It's a formula that we have to look at, looking at your net worth, your debts, your income. We put all of those things together in this formula that the VA provides us, and as long as you're below the $129,000 that we've got listed in here, the numbers I know you're not going to remember, so feel free to reference the slides at slide 38. As long as your net worth is less than that, then we're able to get you qualified. And what that benefit provides, it's a monthly income stream. It's an income stream that is paid to you and deposited into your bank account. It is not something that just gets paid and then right away turned over to the facility or to the in-home care that might be helping. It's paid to you, deposited in your account, and then you use that to pay for your uninsured medical expenses. And so when you have the VA benefit, there's benefits available to the veteran themselves, to their spouse, as well as if they're both veterans, then it's a higher amount that they're able to get on a monthly basis to pay towards these in-home care costs or towards your assisted living costs. Now, the VA aid and attendance pension can certainly pay towards your full skilled nursing, but oftentimes your income plus the VA aid and attendance still isn't enough to make up for what full skilled nursing costs. And so in that scenario is often when we're starting to look at Medicaid. Medicaid is a program that's under the state of Michigan. It's one of many programs. There are other programs that are available before you get to full-skilled nursing. But as we're talking about VA and VA's use on full-skilled nursing, we certainly want to make it known that typically you don't always do both, where you get the VA as well as the Medicaid. Because once you're qualified for Medicaid, the VA benefit is reduced. They recognize that there's a patient pay component to Medicaid. Medicaid is a cost share where you have to pay some of your income. And in fact, the VA doesn't want to provide you income only for you to turn around and pay it back in to another governmental assistance type program. And so that's why that ultimately gets reduced. And so VA is really good throughout all the varying levels that you could go through, whether it's independent, assisted living, or full-skilled nursing. But again, if you have that deficiency between your income and VA for the full-skilled nursing, at that point we might have to look at some additional ways to fund that deficiency. Okay? And so, I'm going to take a breath. You did so well, 10 minutes, I don't think she took a breath. All right, so moving forward, there's often times where we are at home or in an independent living and we are starting to need these services. And maybe we don't qualify for VA aid and attendance. Maybe we don't have a long-term care policy. And so this is where we're looking at who else now can pay. And this is where we start looking at the different Medicaid programs. Medicaid has the My Choice Waiver Program and the PACE program. These are the programs that are available to in-home care or assisted living level of care. The biggest significance that I want people to understand when it comes to the My Choice Waiver Program or to PACE program compared to the type of Medicaid that does pay full-skilled nursing is that when you're in an assisted living institution or organization, there's a base rent. There's a base rent for your room and board, and that varies depending on facility, often between $3,000 and $6,000 a month. But then you have the services, as I was initially talking about. There's the activities of daily living. And as you need more activities of daily living, those services add on to that room and board cost that you have. Each service an additional cost. The My Choice Waiver Program is what pays for those additional services. It doesn't cover that underlying room and board. And so when we're looking at what type of program are we best qualified for, best suited for, we really have to look at the income to see what that deficiency is. If there's going to be a deficiency, how can we get that paid? Is this program right for it? And this is an area that Susan's going to talk a little bit more on in detail. And so the My Choice Waiver, PACE, are available programs in order for us to bring in-home care to you at your home or at an assisted living center. we ultimately move beyond the need for assisted living and do need full skilled nursing. And oftentimes full skilled nursing isn't just for physical, but it can be cognitive impairments as well. You can have no physical ailments and just cognitive with regard to, say, dementia and Alzheimer's or later on down the line, and that alone can require the need for full skilled nursing. Once you reach full skilled nursing level of care, you're looking anywhere between $8,000 to $12,000 a month. This is a big one where everyone is like, how do we pay for this? This is where if your deficiency with your income and potential VA benefit, if it still does not cover that cost, then we're looking at getting Medicaid qualified, seeing if Medicaid can help to assist and pick up and pay for those benefits. And when you are getting qualified for Medicaid, whether it's the My Choice waiver or the full skilled nursing type need, it's the same formula. We have formulas that Medicaid requires of us, and they're different based on whether you're married or whether you're single. And so when we're planning for this, we can plan for the My Choice waiver, but if ultimately you progress into needing full skilled nursing, at that point you're already set up. Most of circumstances you're able to flow through into that and then apply for the Medicaid to then continue the full skilled nursing costs. Okay? And so the idea is to get the planning done as early as possible, see where we're at if we have to move through these stages, and see what income is available to us. When we're talking those Medicaid qualifications, all right, the Medicaid qualifications are first you have your income, and then you have your countable assets. All right, your income, when you're on the waiver program, is actually very strict. You can't be over it. The income amount is $2,360. Get to that. And so if you are only in need of assisted living or in-home care, and your income is $2,370, $10 over the limit, you don't qualify. There's not a way to change that, unfortunately. That's a very strict, hard and fast rule. Once you are in need of full skilled nursing, the income doesn't have that limit threshold. In fact, what it does, it's a cost share program, meaning there's a patient pay component. You have to pay part of your care out of your income each month before Medicaid will pick up and pay the difference. And the reality is, while that doesn't sound great, because we wish we could all keep our income, that $8,000 to $12,000 a month, that's a lot, and Medicaid isn't able to even cover all of that. And so the cost share allows all of us to each pay a portion of our care while Medicaid is able to pick up the rest. And so the general rule when it comes to income and what your patient pay cost share is going to be is all of the income that comes in your name less $60. All of these programs have numbers that change each year. Every January they tend to go up with inflation, except this number. For some reason I have not seen the $60 adjust. Now, there's adjustments when it's a couple, a husband and wife, and there's a mortgage, or there's expenses at home for the spouse that stays at home. There are still allowances to allow them to keep a little bit more than $60, but it really depends on those expenses. Again, it's a formula. It's something I can't just tell you you'll absolutely get or as an absolutely fixed number. It is just something that we work into the formula, we look at your expenses, and then we're able to ask for more of an allowance than the $60. But this causes an issue with a lot of families when the primary person that makes the most income or has the highest Social Security amount is the one that needs to use the facility, because it's the income that comes in their name. The income that stays in the name of the spouse that stays home, it's still theirs, they still get to use it. But then we have that deficiency of the income now that is being paid in. So that household income will go down because of that cost share component of all the income less $60. Okay. I went through a lot of them. So Medicaid.
49.
Yep, 49. So when it comes then to the asset qualification, so that's the income. So there's that cost share component. All of the patient's income less $60 as a general rule is going to be paid in. But what about assets? What assets can we keep and still be entitled to Medicaid, to be qualified for Medicaid? Well, that's different when you have either a couple or an individual. If it's an individual that is not married, $2,000 in countable assets. Those are all of the assets that we can count. Now, we say that like that because there are some that are exempt. All right, and the exemption means it's not going to count towards that countable threshold. They take that out to allow you to still qualify, and one of those is your house, your real estate. And this is the residence that you lived in prior to needing to go into full-skilled nursing or go into the facility. And it's limited to $603,000 in equity in your home. Now in Michigan, it's usually pretty easy to stay underneath. In California, it'd be a big problem. But $603,000 in your home, that's an exempt asset. That's not going to count towards your threshold. Then you are able to keep one car, one automobile that is in your name. You're allowed to have a funeral contract. So prepaid funeral contracts, you're able to purchase for the spouse, yourself and then the spouse. There are, let's see, how do we go? I just don't want to skip ahead too many times. So we did the funeral contracts. The limit on the funeral contracts, so the funeral contracts don't include the luncheons or the flowers and things like that. It is just the payment to the funeral home for the setting up of the funeral. It is limited to $13,160 for the irrevocable funeral contract. And then you can do the one for the spouse that's limited to $11,280. And that one, we recommend the life insurance funded. Now, these are details that we can certainly work out with the funeral homes. I don't want you to get bogged down and confused by the different types of revocable funeral contracts or irrevocable funeral contracts. But just know, those are things that we're able to spend down assets on in order to help get you below that threshold. So as a general rule, when we're doing Medicaid planning or qualification, we're looking at these rules, the income and the asset, and then we're trying to find ways to turn what is a countable asset over into a non-countable asset, whether it's an exempt asset or into an income stream. But those are the different, as a general rule, ways that we're able to get assets down. That process we call the spend down. We're spending down on what Medicaid allows us to have as an exempt asset, and those are things that we typically need. Because once you get on Medicaid and you're down to the $2,000 as an individual person, there's not a lot left to pay for that funeral contract. So these are things that we want to take care of ahead of time before we apply for the Medicaid while we're doing the spend down. When you have a husband and wife scenario, it's not $2,000 anymore. In fact, the husband and wife scenario, it's a little bit harder of a formula. What they want to look at is we first look at what's called the snapshot date, and that's kind of our slang for it. Michigan Department of Health and Human Services calls it the initial asset assessment date. They want to know what is the total countable assets that the husband and wife had as of this particular date. What this date represents is either the date that the patient last left the home or the date that they got assessed as to what level of care they need. And so Department of Health and Human Services says, okay, how much did you have when this need first arose? Let's just call it the first arose date. When this need first arose, whatever you had on that date, by the time you submit that Medicaid application, we have to spend down to half of that, but maxed at $130,360. It's another number that changes every year, but it's about $130,000 right now. And so there's ways that we play with that formula to maximize it so we can be able to save all of that $130,000. But as a general rule, what we do as planners is we take everything over that $130,000 threshold and we turn it into an income stream if we don't have other exempt assets. So first we look through and see what are these Medicaid allowables? What will they let us spend countable dollars on to turn it to an exempt dollars, but still be a useful, valuable asset that we purchased. And so once we go through all those spend downs, those allowables, then we ultimately reach a point where, all right, we've spent down on everything we can, what do we do with the rest? When it's a husband and wife, we turn it into that income stream because the income is counted different from the assets. So that's a whole lot to try to take in and wrap your head around. I understand because we've all been wrapping our heads around it for years. And I certainly don't expect you to wrap your head around it in 15 minutes. So feel free to certainly ask those questions. So we kind of went through, we talked about the funeral. There's a funeral comparison chart in here that goes a little bit more deep to show you that when you get that irrevocable funeral contract or when we help you purchase that as an exempt asset, you're also entitled to a burial space, a burial fund. Those are types of things that we can purchase and continue to take your assets to spend down on assets that are exempt. So things that they're going to count. They're going to, well, let's first state, prenups are not respected. I'm on number 56, slide 56. This is one that we tend to run into a lot nowadays where we have blended families. Blended family situations are where we have a husband and wife, yours, mine, and ours, or some combination thereof scenario. And oftentimes people will come into our office and say, okay, the husband or the wife needs to have some services, let's get Medicaid qualified. Oh, by the way, here's our prenup. Assets go to this family, assets go to this, and they're not to be intermingled. Well, I have a surprise. Michigan Department of Health and Human Services does not care. That doesn't matter to them. That is a legal document that relates to death or divorce only, not Medicaid qualification. And so those are things that we have to work through with the family to see, we have these formulas and they only work a certain way. We can't always do them in a way that keeps that prenup intact. But just recognize that we do try to still work with that as much as we can. Assets of both husband and wife are counted. You're going to look at both of them, again, regardless of what the prenuptial agreement says. These countable assets will include any jointly held property, all real estate that's even other than their home, life insurance. So a lot of people don't realize that the life insurance policy that they carry has a cash surrender value. If it's a whole life policy, it's going to have a cash surrender value, and that amount, that's counted towards that $2,000 or $130,000 threshold. The boats, motorcycles, second cars, RVs, all such recreational equipment are countable assets. So we get online, we find ourselves a Blue Book value, and we have to assign a value to that while we're trying to get somebody qualified. IRAs, retirement plan proceeds. Yep, they're all counted towards that $2,000 or $130,000 threshold. Bank accounts. Continued, countable assets also include any other securities, brokerage accounts, government bonds, tax-exempt investments, cash in a safe deposit box, cash underneath your mattress. They're going to ask you everything. Again, what Susan's about to go through. There's tricky countable assets that tend to come up. Things like land contracts. So if you've sold your house on a land contract, well, how is Michigan Department of Health and Human Services going to look at that? Well, they're going to look at the income stream that you get each month from that land contract, but then they're also going to look at the balance that's owed to you underneath that land contract. These are pretty tricky assets that we have to work together in order to still make them work within that qualification threshold. LLCs, partnerships, family businesses, those are all things that we have to count and we have to value. Interest in family cottages, hunting cabins, other recreational property, anything in a revocable trust. So as Laurie was just talking about with your estate plan, many of you have revocable trusts. It's what, I'd say about 95% of the trusts that get prepared out there is a revocable living trust. When an asset is held in that, it's countable. It's not exempt. So that real estate, that house that we deeded to it, it's not an exempt asset anymore. When it's in the trust, it's countable. But the great thing about that is we're able to use these trusts to help maximize that $130,000 allowance simply by deeding the property in and out. That deed that we use to work with the strategy is within the rules of Medicaid, and essentially that deed is worth the amount of the house in that spend down. And so it's a very broad way to try to explain how we do that, but it's not a bad thing if you're married and you have your house in a revocable living trust right now, just because it's considered countable. In fact, we want it that way. We want it to be in the trust before that initial asset assessment date, the snapshot date I was referring to earlier. And so, other assets. Most annuities are typically going to be countable assets, so if you've got annuities. Joint property held with others. So as Laurie was saying, these are tactics that people will often employ is to add someone to their account. Not only are there the issues that Laurie had mentioned, but if you just happen to be on your son's account because he always had mom on his account, or whatever reason to help him learn how to pay his bills and whatnot, and you never took your name off him, well now his total bank account is counted towards your Medicaid threshold. And so I just emphasize that part because it is not, joint ownership is definitely not a replacement for that power of attorney. When you add someone to your account as a joint owner, it impacts things like Medicaid in a big way. It impacts the unequal distribution, all the things that Laurie had indicated. But when it comes to Medicaid planning, joint ownership on accounts with children is not advised. It becomes a problem that we have to work with the caseworkers.
What about long-term care? contracts.
Yep, so long-term care insurance policies, they often have a period of time that you have to, what do they call that? Yes, the elimination period, that's it, where when you have a long-term care policy, they say, okay, at the start of that disability or that triggering event, there may be 90 days, there may be 6 months before they'll pay. And so when you get through that elimination period, we definitely want to utilize that income towards your care. If that income, coupled with your income, still doesn't make up for that deficiency, then we can still do the planning. However, that income is still going to be counted towards that patient pay amount as long as you're receiving it. Now, everyone's long-term care policy is likely different from the person sitting next to them, as there's varying policies out there. But we will work with each one to see if that long-term care policy elimination period has handled, and if that's going to provide for the in-home care, assisted living, or if you ultimately need to look towards full skilled. Does that answer your question? But it's counted as far as that income.
Okay, thank you.
Penalty for divesting. And so, this kind of brings us to the divesting period. Can you start? Okay. All right. So, as far as I was talking about your allowables, your spend downs, the things that Medicaid allows us to do, which is your funeral contracts, purchasing, making exempt renovations to that exempt home. Those are the allowable spend downs. But you reach a point where you've done all of those things, all the things that Medicaid says, all right, we're not going to penalize you for it. So then we move on to what's called divestment. Divestment, this is on the bottom screen 60. Divesting is where you actually get rid of property out of your name. At that point, Susan is going to let you know exactly how getting property out of your name for less than fair market value is going to hinder you. There's a penalty amount of $9,560, and she's going to explain exactly what that means.
Ooh, I'm tired. All right. Well, you've heard a lot of numbers, you've heard a lot of rules, you've heard a lot of do's and don'ts, and I'm going to tell you how I look at that, because this is the eyes glazing over and the eyes rolling in the back of heads. When I meet with my clients, I see a little bit of that out here. So this is how I visualize it and I think of it, okay? You and your family have been driven in a bus out to a big field. You've been let off in the middle of the field. Bus driver goes, just don't break the rules. And you go, what are the rules? And they go, oh, no, we're not gonna tell you. We're just don't break them, because we're gonna penalize you for that. Well, just tell me the rules. We will when you break them. And by the way, we've been watching you for the last 5 years. We know everything you've done for the last 5 years. You've already got some penalties going on. Welcome to Medicaid. Okay? You don't know what the rules are. You don't know that because you never thought you would be here. You never thought you would be having to do this. And here you are in our office, and you just found out that what you did 3.5 years ago is now going to cause you trouble. And you did it as a well-meaning person. Okay? So divestment is like breaking the Medicaid law. Don't break the rules. What is the rule? Don't give away any money, any assets, for any reason. That means there's no helping your kids, there's no helping a neighbor, there's no paying tuition for your grandchild's Christian school education. We can kind of get away with a tithe to your local church, your home church, but a tithe, okay? That is not at the end of the year, the building fund wants 10,000, okay? That's not okay. That's what we do as a community, but that is divestment. So, let's say you're in the position of having to file for Medicaid for your spouse. They look back from the time that we file. They go back 5 years into your business, and they look under every rock, every stone. And by the way, they already know what you did. They're waiting for you to confess. They add all of it up into one pot, all of it. And you divide that by 9,560. That's the magic number for this year. Every year it changes. That calculation gives you the penalty period for you not getting Medicaid. If you're a single person and you've done this, you're in a world of hurt because there's no money left. Remember, you can't have more than $2,000. What if you have a 4-month penalty? For 4 months, Medicaid's not paying. So this is the eyes wide open. I want you all to remember this and this day. From here on forward, don't give away anything but a tithe to your home church if you want to be safe. Now, not everybody in here is going to nursing. Not everybody in here will ever file for Medicaid. So this is your decision, but eyes wide open, okay? So if you don't want the tail to wag the dog, you make that decision, but understand it may be your family that's paying the penalty and not you, okay? So that's divestment, and the penalty hangs on. In other words, on slide 60, the hanging penalty means you don't get penalized when you do it. You get penalized when you file for Medicaid. So they just keep track of it all, okay? And they have an asset detector that will find it, okay? We had a single lady with Alzheimer's, and she used to live like in South Dakota or something, and she moved to Michigan to be with her family and so forth. We filed for Medicaid for her, and about 2 months after we filed, we got a notice that she was disqualified because they found that out in South Dakota, she had like a $3,000 or $4,000 CD, and with her Alzheimer's, she didn't remember that. So, you know, it's those kinds of things that we just have to say, okay, we'll take the CD, we'll pay it to the facility, and is all forgiven, you know, hoping that they'll work with us on that. There's no guarantee on that. So, Medicaid has a few transfers that are allowed, not divestment, but very few. And so the idea is if you're paying something, it better be fair market value, okay? You're not gonna sell your winter beater car to your grandson for $1, okay? It's fair market value. So that is, if it's fair market, it's not a divestment. Paying bills, purchasing exempt assets like the funeral contracts, paying down debt, and any transfers between husband and wife are fine. You guys are a unit, okay? You're not individuals, so it's okay, whatever you do between the two of you is not the same for anybody else. For anybody else, it is not okay to give away money. You can transfer assets to a qualified trust for a disabled child or just to a disabled child. So it has to be Social Security disabled. So it's got to be a really, not just somebody's kind of having trouble. It's got to be Social Security disabled. And caregiver contracts are going to be looked at as divestment caregiver means I'm paying someone to come to my residence and take care of me or my spouse. Okay, we're not in a facility, we're paying someone to come in. That is not okay with Medicaid unless you meet very, very strict guidelines. It kind of whirls around activities of daily living. You've got to get a doctor's. It's almost like a prescription for care at home. They've got to be very, very specific about how much time, what activity, how many times a week, that sort of thing. And it mostly is looked at as divestment, especially if the caregiver is a family member. Because you're just paying your granddaughter to come play Scrabble with you, right? I mean, that's what they're gonna say. So you have to be really, really careful about paying someone in the house. All right. Now, Bobbi went through a bunch of the numbers for qualifying for Medicaid. So I want to kind of tell you, I could retire if I had $1 for every time somebody says, well, it's just a booklet, right? I mean, you just fill out this 5 or 6 page booklet. And I say, you mean this? This? Yeah, that's what you do, right? It is, if you do this, you will get it back in about a month and it'll go denied. Okay? That's all. And then we start over. And in the meantime, you're paying privately. This is like the 1% of the process. This is, when I get down to filling out an application, I'm home. I'm done. Let me show you reality. This is step 1. Okay? It is, dear caseworker, we have a snapshot date right there. Here's all the proofs about the snapshot date only. Okay? And it's not just about assets. It's here's our birth certificates, all of our cards, our marriage license. Oh, the marriage license. You better be married. We had one of those. And I will tell you, I will never forget this day. I know what I wore that day. I mean, it's in my mind like that. I was in the conference room with Mom and Dad and their 3 kids, adult kids. And Mom was not well and she was going to be going into nursing. And I gave them the list of all the stuff they had to get me for this step 1. And I said, oh, we're still missing the marriage license. She goes, well, we just can't find it. Well, I think the husband said that. And I said, well, you gotta find it, or you gotta apply for a replacement, or go to the minister, whatever. It was a long pause. And they said, well, we just never got around to it. And the kids are, what? You're not married? And one of the sons said, Mom, on any given Saturday, you could have done this. So we don't have a married couple for that. We had an individual who could only have $2,000. She can't give it to him because he's not her husband. So everything with her name on it had to be spent. So, find the marriage license, okay? That's just words. So, step 1. Now, after we know the number at the bottom of the page, that's all of the countable assets on the snapshot date. Then, we have this is step 3. you might, and this tells the caseworker, oh, we're down to the magic number that we figured out based on what we had at the snapshot date. Half, but no more than, okay? So the calculation on slide number 72, if you can find that, 72 and 73 are the ones that I want to work on here for a second. It shows you half but no more than. How do you figure that out? So if the married couple has 100,000, half is pretty easy, isn't it? 50 and 50. So the spouse at home gets the left-hand box. The spend down is what we do with everything above the 2,000 that the institutionalized spouse can have. So we got to spend down $48,000, okay? And that's all the spendable things. That's where we look at, okay, do you have a funeral? Do you have any debts? Do you have that kind of thing? The next slide says, okay, but what if we had 300,000? Half, but no more than. So the but no more than number changes every year. This year, it's 130,380. So at 300,000, you can't keep 150. That's the half, but it's the but no more than number that you have to really hone in on. So we have to spend 167 now out of the 300. So that's where we get creative, okay? That's where we want to see if we can create some income for the spouse at home, all right? And that is a pretty complicated thing to do, but this group here does it every month of every year. So it is complicated. What you don't do is, first of all, you don't panic. You just let us know and we'll walk you through it. But I just really want you to understand that you have a lot of well-meaning people in your lives. Okay, there's a lot of people who say, I did that, about 2 decades ago for my Aunt Margaret, and it didn't go so hard. I don't think that's that hard. Well, maybe Aunt Margaret was under different rules because they get worse every year. And maybe for her, she was a single person and she didn't have much. Yeah, that's pretty simple, okay? Married couple stuff is harder. So in between step number 1 and step number 3 is the spend down. That's where we turn the excess assets into exempt assets or an income stream. So the income stream takes the excess assets off the table, shoots it up into a pension income that dribbles it back to you on a specified amount of time. Sometimes we pick 2 years, sometimes 3 years. Medicaid has a life expectancy for all of you. It's in a table, I can tell you. But you have to have it inside of your life expectancy. So we usually pick a couple of years less than that. And we can pick anything from 3 to 6 months to 5 or 6 years, just depending on what your other income is. So we do the entire spend down, and then I say, okay, here's the finished product, and we're down to the but no more than number. And then it sits we send it in, and it gets back to us in usually 2 to 3 weeks, sometimes a month. And they do not say, congratulations, well done. I swear they are mandated to deny every single one. And so, they pick on something. Or actually, it's usually about, 3 different volleys of verification checklists. They call it a checklist. It's an audit. okay? Let's just call it what it is. It's an audit. And they say, here's 27 things I don't like about your application. And you've got 5 to 7 business days, really, 5 to 7 business days to correct it all or to provide this. So last year during COVID, we didn't get the notice until the day was due. Okay? So when we file a Medicaid application, we tell the family, you have got to get on top of this. And you have got to make sure that you have 5 years of bank statements, of investment stuff. You just have to have all of your paper. So in this world of green, go green. No, keep your statements, okay? Get them at your house. If you can't print them off, then you've got to have 5 years of statements. Just get accordion files, put everything in a year, and shove it to the back of the closet. At least you'll have it if we need it, okay? Eyes wide open, don't go green. Keep all your stuff. Just like your 1099s, keep all your tax returns, keep all of the, like if you close an account from one bank, don't just say, oh good, we're done, and put it in the trash. Keep it. You have to prove, because they have 5 years worth. They go, wait a minute, you had a Huntington account, what, 3 years ago, where's that? Prove that you don't own it. Well, how do you do that? I don't own it. Well, prove it, okay? Remember, 5 days, it's ticking away. Now, maybe you can get to Huntington, and maybe they can find something, and maybe they'll write you a letter that says it's closed. Maybe, maybe not. So if you have it, we're ahead of the game. We turn over those proofs, they come back, and they say, now we want 11. And sometimes the 11, 7 of those things were inside of the first 27, so we give it to them again. The whole concept is get them whittled down to where they say approved. Okay? So this is just one, this is the first verification checklist. So this is one very, very normal couple. Very normal couple. Nothing, we didn't have oil rights in Tennessee. We didn't have timeshares in Louisiana. We didn't have a family LLC cottage. We didn't have any of that. This is black and white, probably every one of you. Okay? That's a Medicaid application. All right? So the reason that we like to come ahead of time is because you all are hearing this and you have the opportunity to do things differently going forward to make sure that this process, if you have to go through it, is, this wasn't a bad one. It was normal. I mean, we have some, I couldn't carry some of them in here. Okay, we have boxes and boxes of them. So I just want you to be well aware and remember, you're all just being dumped out in the field and not told what the rules are. Well, I snuck into that bus and I'm telling you what the rules are, okay? So that you know how to play this game, and maybe you will be blessed by never having to go through this, and wouldn't that be nice, okay?
How do you get blessed?
Well, you don't have rugs on your floor, you take your vitamins, you don't change your own light bulbs, okay? All right? You stay as safe and healthy as you possibly can, but be prepared, okay? Just if you're prepared, then we can help you through this. But, there are things we can't undo. So, you've all got a head start.
What do you have to charge? What do you have to charge to do this?
It's an hourly rate, okay? Okay, so it's hourly. So, okay, the bigger the mess, the bigger the bill. So when people come and they have truthfully I've had bushel baskets brought into the conference room. Lots of, paper bags full of, who knows? Okay. You're paying me to go through your stuff. And so, if it's not too terrible, it's sometimes about the same cost as a month in the nursing home in that area, okay? It's not a cap, it's a kind of a guesstimate, but we keep track of every quarter hour we spend. And so Lauren and I, we do a lot of the document crunching and so forth, because these two are expensive. But so worth it. Yeah. So we do the number crunching, we meet with you, we tell you, no, you're missing 1, 7, and 8 on our list, go back, send it in. We can, we come out here quite often to meet with you guys. That's doable too. I know it's like people break out in hives when I say we have a downtown office. So I have told you a bunch of the don'ts. Lauren's going to share how to be a little bit more proactive, and it may be a little bit more upbeat. Maybe. I don't know. Yeah.
Okay, so I have some of the do's, which is probably going to make your file cabinets very, very full. But, like Susan said, the more information that you guys retain and have organized in advance of applying for Medicaid or preparing for Medicaid, the better off you're going to be. So, for example, bank accounts. A lot of you are probably getting online statements now. Some of you probably still get paper. But you'll notice if you look back in your bank account online, you can only go back so far. So if you've got, maybe 9 months, 12 months, 3 years, I don't think I've seen much more than 3 years. Now, if you can pull 3 years worth of bank statements back, that's great, but we're still missing 2 years. So what happens then? You go to the bank, you get the information, and they charge you $5 a statement. That's kind of expensive when you had all of those things in hand to start with. So I would highly recommend that you gather those bank statements, hold on to them for 60 months. So that's 5 years, but they do it by month. So instead of doing like a calendar year, it would just be, as the months drop off, you can start pitching some of that stuff. So same thing goes with, if you're closing accounts, hold on to that, closure notice. So if you get a last statement that says closed on it, we'll probably be asking for that. So again, hold it for 5 years. We want to know where that money went. So a copy of the bank statement showing, I closed this CD out and I opened this other one. Or I closed this CD out and I deposited it into my checking account. So we need to be able to trace that step by step as to where your money went. So all of that stuff, that 5 year is your golden number. Remember 5 years, and it's 5 years from application date. So unfortunately, none of us have a crystal ball. If any of you do, I would like to know. But yeah, I'd like to borrow it. So, we don't know 5 years from today that you're going to have something happen. If we had that knowledge, we'd all be rich, but we would be able to prepare better. So in this case, if you can gather those things with the expectation of the unknown. Obviously none of you want to apply for Medicaid, none of you want to go through this, and it might ultimately not be your problem, but it's going to be somebody. So it might be a kid, might be a spouse, and I know nobody wants to do that to, their family members or their friends, because it's a lot more difficult when you don't know what the assets are. So another thing that's helpful, and I work through this with my family, is it's good to have a list of your assets somewhere. Who owns it? Who's the beneficiary? What type of account is it? Is it a life insurance policy? Do we know, is there a living beneficiary on it? Did we have a spouse that passed away and we never updated some of this stuff? So even just tracking down some of those items are extremely helpful. For example, my grandpa passed recently and we're going through his stuff. Well, come to find out, my grandma had no idea what was going on with their finances. Now we're finding stock policies that were in his name that we didn't know existed. life insurance policies that we didn't know existed, some of these things don't have beneficiaries, which is kind of crummy, because now they've got to figure out the probate side of things, they've got to hire an attorney, you know, they've got to go through all these extra steps. So even though that's not fully Medicaid oriented, it kind of goes along the way. Medicaid and estate planning a lot of times is really hand in hand. If your estate planning stuff is done with a good elder law attorney, you're probably going in the right direction. So along with some of that stuff, it's definitely important to make sure your estate plan is updated. You know, if you've had a change, say you've moved into an assisted living facility, or you've got a spouse whose health is significantly declining and it's been a little bit since you've had your estate plan updated, it's definitely worth talking to somebody. You know, we can issue spot if you've got a weird land contract that, you know, you kind of just put to the side and forgot about. So there's lots of things that can be issue spotted in advance. So if you have something and you're kind of scratching your head, while any of us were talking, I would highly advise maybe give a call to someone, your attorney, one of these lovely ladies are fabulous. But we can definitely talk you through. Maybe there's nothing that needs to be done, but that peace of mind is definitely worth a lot. I'm trying to think if there's anything else. Mostly just on your paperwork, please don't throw it away. Whether I want it or not, I do want it. So that's, yeah, go ahead.
What else should we keep besides our bank statements for 5 years?
Okay, so it's gonna be any type of asset statement.
Can you repeat the questions, please?
Yeah, so he asked, what do you specifically keep other than the bank statements? So what I'm gonna be looking for is, you know, bank statements, annuity statements that you're getting, life insurance statements that you're getting, stock statements if you're getting something from AST or Computer Share, or if you've got like an old school stock certificate, hold on to those types of things. Trying to think what else is on that listing. Yeah, tax returns, so you know, the little stubs that people tend to throw away that you give to your CPA, those I would like to see. Because those give me little bits of information that perhaps, you know, we forgot a little something. So those are extremely helpful. I also like to look through some of the schedules on those tax returns just to figure out, you know, hey, was there another little piece of income or something funky going on that may tip me off to something else that's out there. Yeah, so basically any deeds to real estate, I would like those. Any kind of, you know, assessments that are done on those real estate, I would also like those, because sometimes I can pull them, sometimes you gotta pay for them, or they're a little bit trickier to obtain. So I would hold on to any of that. So basically any assets that you've got, 5 years of whatever you're getting in the mail, or you're closing, or you're opening, that is what you're gonna want. So I would just, yep, go ahead.
If we have an IRA, but it's in her name, not my name,
Yep.
does that enter into the spin down then?
I'm assuming you guys are married.
Yes.
And you have a marriage license.
Okay, so he wants to know if they are applying and the IRA is in his wife's name, is that part of the spend down? So yes, it's part, well, I shouldn't say yes, it depends. So if it fits within the limit that you are allowed to keep, you don't necessarily have to spend that item down. But if it is above that and we can't fit it in kind of your keep pot, then there are options to spend it down without necessarily spending it exactly. That's probably a deeper conversation. I don't know that we necessarily want to go down the rabbit hole. Yeah, but everything, you know, they're gonna count that, so we're gonna have to figure out something to do with that.
One more question.
Yep, go for it.
Whole life insurance, you get a cash value.
Yes, countable.
They can suck that away from you then?
They can, yep.
So what do you do with it then?
Let me talk to that a little bit. The life insurance.
What's the question? Repeat the question, please.
Okay, so if you have a whole life policy, does that count, and can they, I think you said, suck it away from you?
Yeah.
So yes, the answer is yes. It's an asset. The cash value portion of it is, so there are different things that you can do. So I'm working with one right now where there's a $25,000 cash value, but the death benefit is $75,000. So the spouse gets to keep the but no more than 130 number. So we're counting the 25,000 of cash value as an asset, because that's what it is, so that when her spouse dies, she gets the 75, rather than surrendering it and only getting the 25. We've also had it where a child can, because remember, Medicaid says the 25 is an asset, it's cash. If a child buys it from, say, her dad, and let's say he's single and there is no spouse, and he's got this cash value life insurance policy with a nice big death benefit. The child can buy it for the cash value and change the ownership to him or herself. Now, they own it. They will be the beneficiary upon mom or dad's death. And the 25 went to the nursing home spouse or the resident, and they can use that to buy a funeral, to pay debt, or to pay the nursing. But at the end of the 25, they're on Medicaid, and the child gets the benefit of having a $75,000 payment when her parent dies. So we really have to look at everything really individually. Maybe nobody comes up with 25,000, maybe nobody has that. And that's okay, it's just an option, but that's a pretty nice option. Yes?
I had two quick questions. First of all, are you saying that if we, with our pension and retirement, our pension and Social Security, if it's more than the 2,200 we will never qualify for Medicaid?
If you're in a nursing home, there is no cap on your income unless your income is as much or more than the cost of the nursing. Very few people have $11,000 of income each month. Income is different than an asset. Asset is what do I have right now in the bank that's money. Income is incoming, okay? It doesn't become an asset until it's in.
So how irrevocable is irrevocable?
Pretty.
Yep, so I think the question that you're going around to is that limit, that income limit of 2,360, that is that strict rule for the waiver program. And the waiver is where you are having them pay for your services in either assisted living or your in-home services. And so that's just a different program. Once you need full skilled nursing, or if somebody needs full skilled nursing, that income has the cost share component where you have to pay all of it except 60. And so your strict requirement is, yes, if you're over 2360, you don't qualify for the waiver or for the PACE, but you will qualify for the Medicaid, given all the other qualification requirements. Does that? Oh, and so the other question was, how irrevocable is an irrevocable trust? It is, in fact, irrevocable. If it is done correctly for the purpose that it's usually intended, it is completed. It is considered a completed gift. You have given it to this irrevocable trust, and you can never demand it back.
But nobody else can take it either.
They should not. So the terms of the trust will indicate who and what it's for, but it does come out of your name, and you cannot bring it back. And it is considered a divestment. So for Medicaid purposes, if you put assets into an irrevocable trust, they look at that as a gift, unless the trust paid you for it, but typically that's not how it works. You just transfer assets to it, and any time within the 5 years after you've transferred those assets to that trust, Medicaid's going to look at that.
Dale.
On these records that we have to keep bank statements for every month of the year, not just the end of the year statement.
Right.
In investments, though, with your investment account, you get the end of the year one has all the transactions for the year. That you don't need all the.
Technically, they can ask for anything they want inside of a 5-year period. Normally, what I'm seeing, and I don't know what you're seeing, but it's the typical is 2 to 3 years. but they can ask for 5. Kind of depends on the caseworker and what county and what's going on. If they see something from 2 years ago, or you have a lot of gifts, I mean like a lot of gifts, or cash, you have a lot of cash, or you have, when the CPA said you can give 10,000 per person per child, or 12,000 or whatever, and if your CPA says it, of course it's true. Of course it's true, there's not a period. It's a ... Okay? The next words are, unless you file for Medicaid. Okay? So that needs to be bold italics. Unless you file for Medicaid, yeah, you can. But can you guarantee that you won't file for Medicaid? So just because your CPA says, yes, you can, it doesn't mean you should.
I'm going to add on to that just a little bit. I know we have to give a break, and we'll get to a break in just a second. But your question with regard to can we or should we just keep the end of the year versus the quarterly statements that come, I recommend still keeping the quarterly for the main reason that I ran into, which is when you have that husband-wife scenario and you have a snapshot date and you need to know the value of the assets on that snapshot date, it's very difficult. And not all types of investments allow you to go back and look at a certain date to see exactly the value. And so having it as close as possible, the quarterly statements, because you don't know exactly when that snapshot's going to be. The snapshot date comes into play when there's an injury. Most oftentimes we see it where one of the spouses ends up being injured, or they break something and they go into the hospital, and then from the hospital they go to rehab. And then once they're in rehab, then at that point, whether or not they progress or decline in their care is really going to be the catapult to, are we going to end up applying for Medicaid? Because as long as they are progressing in their care, Medicare will continue to pay that state, but only up to 100 days. And if they end up declining or just plateauing, then now we have a situation where it's self-pay, and we start looking at Medicaid. But what we have to do is still determine what was the value of that asset as of the snapshot date. And in that scenario, the snapshot date is going to be the date that they fell and got hurt and went into the hospital, not the date that they were in that rehab facility, not the date that Medicare cut off. And so going back to pull those numbers on investments specifically can be difficult and trying depending on how the account is held. So I definitely encourage still keeping the quarterly statements as well.
What do you do if you've already switched to the green method and you're not getting?
Start today. Okay, so her question was, what if you've already switched to the green method? What do you do now? So if it's a bank, you can go online, you can change it, you can go into the branch, you can tell them, hey, I really like getting the paper statements, can we swap this back? Same thing goes, if it's financial advisor for investments, if it's something like a life insurance policy, it may require a 1-800 number call, which isn't so much fun. Yeah, if you have an online account that you can print them, you could do that too. So if you have access online through your bank account and you're getting green statements, you could go ahead and just hit the print button, print it off your home printer and hold on to that, and that would be acceptable as well. Okay, anybody else?
This is all within this 5-year period that we're talking about. Anything before that, so from today on, we are all obliged to wait for 5 years. Yes.
Okay, so her question was, is this all, after the 5 years, once you're outside of the 5 years, does it fall off? So yes, it would be 5 years from date of application. So it doesn't mean today, doesn't mean tomorrow, it's that date that we're doing the application. So there is a for Medicaid, yes, correct. Yep, so there is a possibility, you could fall, you could be in for a little bit on your own, and you're self-paying for a month, 2 months, 3 months. If you apply in month 4, it's going to be 5 years back from that month 4, not from the date that you went in. It's the application month. Yep. Go ahead.
What about 25-year bond investment?
Okay, so his question was, what about 25-year bond investments? So yes, those are countable as well. We would have to look and see what the value was to determine what to do with it. I've had a couple that we've ended up cashing out. I've had some that I've kept. It just really depends. We need to look at it as a whole. But I would imagine you have some kind of bond certificate of some sort, like a hard copy.
Not taxable.
It's not taxable. So what they're looking for is just the countable value. So regardless of whether it's taxed or not, they're still gonna wanna look at that, if it's worth $500 today, then that's what it's gonna be countable for. So it's whatever you would walk into the bank and be able to receive is the countable value of it, okay? Yeah, go ahead.
Is it important to get update if it's on a trust if a spouse dies?
Okay, so her question was, do you need to get an update on a trust if a spouse dies? So I'm actually gonna let one of the attorneys handle this one.
Typically, when a spouse does pass, it is absolutely a good time to look at your estate planning documents and see if there needs to be a change. Not all the time do changes need to be made, and often when we're doing our planning for a husband-wife scenario, we're planning for that alternative already. We're planning that things will transfer to that surviving spouse, and then after the surviving spouse, then on to the children. And so a great majority of the time, it's already worked in the alternatives if you did it with an estate planning elder law attorney. But it's definitely a good time to look at it. At least look at it, make sure your trustees are still who you want to be managing your trust after your passing. And then you want to make sure the beneficiaries are still the same people that you want to benefit from it. But I think the most important at that stage when you lose a spouse is also to go back and look at all the assets and look at all the beneficiary designations. Because your beneficiary designation is going to take priority over what your trust says. And so if you fail to put beneficiary designations on assets, if there's nothing there, it's going to probate. And then your will is likely to pour over into your trust, but there's still the probate administration that is needed. If you have your child listed as a beneficiary, then it's going to go right to that child. But if you intended a trust to go equally to, say, your 3 children, now you have an unequal distribution. And so it's really important to at least look at the documents, make sure the trustees are who you want, the beneficiaries are who you want, and then look at your actual assets and who is listed as the beneficiary on that. Is it individuals or is it that trust?
And is it important to have an EIN number? I was told that trust needs a number.
The question was, is it important to have an EIN number? An EIN number is a taxpayer identification number that the IRS assigns and uses for purposes of tax liability. In your standard revocable living trust that you have during your lifetime, this is a pass-through trust. There is no need for a separate taxpayer identification number. In fact, it is your own Social Security number. If it's a joint trust, it's one of the spouses. You only need a separate taxpayer identification when you have an irrevocable trust. Because an irrevocable trust it's a separate entity. You have created it in order to hold this asset, and now it's no longer yours. It can't be taxed on your income. It's going to be taxed at the taxpayer identification number we have now assigned to that trust. Does that answer your question?
Talk about like the Ellis Trust where it would partially revocable.
Yes. Oh, okay. So there are some attorneys in our industry that will make it so that a revocable trust that's between a husband and wife becomes irrevocable on the first passing. I don't care for those myself, which was the hesitancy you just saw, because of the complexity that comes with that. And when it does become irrevocable, that is when we have to assign a new taxpayer identification number. And that is when we have to look at then tax implications to this trust because it's become irrevocable. And so that that's an option or something that is in your trust that after the passing of one of you it becomes irrevocable, then the taxpayer identification number would be necessary.
Are you saying that if my irrevocable trust is more than 5 years old and nothing has been added to it, then there's no problem?
Correct. If the assets that you put in at the date that you signed to put it in the trust, not the date the trust was made, but the date that you signed it out of your name, if that's been more than 5 years from the day that you applied, it's off balance sheet.
Okay, anybody else? Go for it.
Going back to the IRA, since her name, I go and ask for Medicaid. Do I have to spend out part of her IRA?
Okay, so his question was, again, IRA is in the name of his wife. He is going to be the Medicaid applicant, and he is the one that needs benefits. So does he have to spend down part of her IRA in order to reach eligibility? So without seeing all of your finances, I don't know, but there is a potential, yes. So it would depend on where your numbers would fall and what your eligibility figure is. So we do the, total up all the assets on the snapshot date, cut them in half, but no more than, whatever that but no more than number is, all of your countable assets have to fit in there. So we would have to determine where her IRA fits within that.
So basically, if that IRA is $130,000 and $130,340 or more, there's definitely going to be some type of change that needs to be made with that IRA. But if it is less than that amount, then that amount coupled with all your other countable assets still needs to be below that 130,000 threshold, provided you're able to use the max with that half formula. That makes sense?
130,000?
That's the max, so that's that but no more than number. So you're allowed to keep half of what you had at the snapshot date maxed at that 130,000. So if you've been able to max that out, that as of the snapshot date you had more than 260,000, and you're able to max out 130, if that IRA is say 80,000 and you don't want to cash it out, then we have to do something to make sure all the other assets are less than 50,000. Because the 80 of the IRA plus all your other countables still has to be below 130. So oftentimes people will want to keep the IRA. And so what we will do is look at the other assets. Are there other assets that we can cash out, that we can spend down, that are more liquid without tax implications as an IRA would?
So what you're saying, in other words, is spend everything that you get below that amount.
That is in fact what we try to do with you, or help you to do.
But you don't want to do it now. That's one of the things that people sometimes do is they panic and they spend down too soon. So this whole spend down process, remember, is not step 1 or step 0, it's step 2. So step 1 is you need to have somebody who goes into a skilled nursing facility. That's step 1, figuring out that initial assessment. Step 2 is spending down. So if you're just living your life right now, just continue to live your life right now. There's no reason to accelerate doing that. There's no such thing as a spend down until somebody goes into a skilled nursing facility. So with a married couple, if you started out with $100,000 and your wife's IRA was $50,000, and you panicked and said, oh my gosh, we just went to this lecture and they said we have to spend down. You hurried up and spent her $50,000, and then you took a fall. You've only got $50,000 left. You don't get to keep half of $100,000. You get to keep half of what you had when on that initial assessment date. So don't panic. The spending down happens after something happens where you're going to be in a skilled nursing facility. So don't panic.
Well, and the other important thing I think would be good to point out is that usually when we do propose a spend down for our clients, it's relatively quick. So it's not like, you've got, say you have excess money in that IRA that needs to be spent. Usually within a month, we can get you to where you need to be without, needlessly spending on just stuff just to spend your money down. So I do think Laurie's point is very valid. Don't panic, don't spend in advance. If you're extremely concerned about it, you can always set up an appointment. We can talk to you about it too, if that would, if that helps.
Well, you would get 6,000 right off the bat, so.
I don't know. I don't do the billing. Go ahead.
Is there a way to remain married and split your assets before you get to the Medicaid eligibility?
So the question is there a way to remain married and split your assets before you get to Medicaid eligibility? And the answer is probably not. So we have a case right now where a client has a order of separate maintenance, and that's not good enough. Either you're married or you're divorced. And so there are other techniques, that if you're in a second marriage, for example, that you can use to shelter assets for your family. But typically Medicaid says either you're married or you're divorced. There's not really a middle ground between the two. I think we're at 3:30 and I know there's cookies. All of us will stick around for a while if you have questions. So please, I'm sorry. So please take advantage of the cookies. we will be here for questions. We really appreciate your attention. We really appreciate Holland Home for hosting us. We think Holland Home does a fantastic job, and I hope all of you are very happy with us. Thank you.